Yes, sir. Good morning.
Good morning. May it please the Court, my name is Attorney Jeff Dubosk, and I represent the appellant Gregory Bartlett in this case. Your Honors, we have basically one issue for the Court's consideration this morning on this case, and it's based on whether a Merrimack police officer making a stop in another jurisdiction, that being Amesbury, and eventually calling the Amesbury police, whether or not that was a legal stop of the vehicle. And it's our position that it was not. As Your Honors know, there's several statutes in Massachusetts that have expanded the common law rules regarding when a police officer can make a warrantless arrest or stop outside of their own jurisdiction. In this case, Judge Welch, the trial judge, basically hung his hat on two theories. One is the mutual aid agreements, which is statutorily allowed by Chapter 40, Section 8G, and there's two requirements there. One is that the circumstances require an immediate response or action for the good of the public safety, and number two is notification to the host community as soon as practically possible.
That's under the mutual aid agreement itself.
That's correct, Judge. And that was in evidence at the motion to suppress. It's our position that this case is factually different from a lot of the other cases that have dealt with extraterritorial stops, and that, by that I mean, one, this is a Merrimack police officer in Amesbury. Nothing was witnessed by the Merrimack police officer in Merrimack. The observations he made were, I believe he said 20 seconds of seeing my client's vehicle cross the yellow line once and the fog line 3 times. Over the course of,
didn't it cross it 4 times and 3 times?
I believe it was the yellow line once and the fog line 3 times, for a total of 4, Judge.
But in the mutual aid agreement itself, the paragraph 3 that you've just referenced,
Correct.
doesn't say, it doesn't have any language about this has to start in your own jurisdiction, does it?
It doesn't. It doesn't.
And do you think the statute requires that?
No, what I'm saying is that, putting that issue aside, even if the mutual aid agreement would allow this officer to make the stop in Amesbury, he still has not met the requirements under Section 1, Bullet Point 3. Number one, it was not a circumstance requiring an immediate response. I'm comparing it to the other cases that Your Honors have decided, cases that have been significantly more egregious, where people have almost crashed into a cruiser head-on.
But the judge did find that the officer reasonably suspected that your client was under the influence, right?
He did. He did. His observations were based exclusively on crossing the yellow line and the fog lines. There was nothing else. There was no traffic violations. There was nothing else that he did.
Coming to an abrupt stop right before he scooted into the restaurant parking lot.
That's true, Judge. There was, I believe that he said he came to an abrupt stop, put his blinker on, and pulled into the Chinese restaurant.
And then parked in a funny kind of way.
He basically pulled a U-turn, and the officer pulled in and blocked him in.
Right.
And
it wasn't really a parking spot.
It was not. That's correct. It wasn't one of the spots right in front of the restaurant.
Right.
Actually, it's been there many times, so I know.
Is it your position that when an officer sees somebody who he believes to be driving drunk, that is not an action for the good of public safety to stop that driver?
Certainly I cannot say that, Judge. That would be irresponsible.
Okay.
What I am saying, Your Honor, is that if he makes an observation of somebody who, in another jurisdiction, who is committing a Mark Lanes violation and pulls into a restaurant and stops his car, he does not have the right at that point to pull in front of him and stop him. He's not free to leave. He has been stopped and seized. And I think at that point he has exceeded the scope of his authority.
But is the issue then whether or not the inference that the officer could make from his observation sufficient to permit him to conclude that the person was probably driving drunk?
Well, I think it would, certainly it could. And at that point, he should be calling the Amesbury Police Department.
So you're saying that if this had happened in the town of Merrimack, this police officer would have had would have been justified in at least stopping him to inquire if he was drunk?
He would have had the authorization. He certainly could have stopped him to give him a ticket for the civil infraction of crossing Mark Lanes.
Okay, so isn't the mutual aid agreement, isn't it self-activating? It can be activated under the statute and under the agreement. It can be activated by an officer in by the extraterritorial officer.
That's correct.
It can be.
It can be.
So legally he could have exercised his authority as a police officer in Amesbury if he had reasonable cause to believe that this person had been driving drunk.
Well, yes. I mean, there's three different circumstances in the mutual aid agreement that allow officers from one jurisdiction to make stops and arrests in other jurisdictions. And the third one, if I could just have one moment, the actual language is when circumstances arise dictating an immediate response or action for the good of the public safety. That's the first element of it. The second element is that the officer should notify the host community as soon as practically possible.
Well, and what do you say wasn't met here of those two requirements?
Well, first of all, my argument on the first point is not as strong, I think, as on the second point. I think that if he sees somebody cross marked lanes, he said he would have stopped him in Merrimack anyways. When my client pulled into the restaurant, at that point, any harm to the public has been diminished. He's now in a parking lot.
But as you said, he's making a U-turn. He's going to go right out again.
Well, that's the facts that came out of the motion to suppress was that he pulled in and stopped his vehicle.
Well, he didn't get out of the car and go into the restaurant, did he?
I'm sorry?
He didn't get out of the car and go in and have a Chinese meal, did he?
He did not. The second element...
Is there any reason to think that the engine was turned off?
There was no evidence as to that, Judge. Not at the motion to suppress.
So the police officer wouldn't have known whether or not he planned to continue driving?
Well, the officer said that he stopped in the parking lot. And then he pulled in...
No, but that he wasn't about to go again. I mean, how would the officer have been able to tell?
He wouldn't have been able to tell other than he testified that the vehicle came to a stop in the parking lot. He didn't come to a stop. There was no evidence that he came to a stop, turned his lights off, and turned the key off. There's no evidence of that. But the other issue, and the second part of the mutual aid agreement as to bullet point 3, is the notification of the host community in a reasonably practically soon manner. And that didn't occur here, and that's a hotly contested issue.
He
called him
did
up.
notice. The judge made findings.
I mean, the judge made a finding that there was notification within 1 minute. The testimony from the Amesbury police officer, the host community, was that the pullover is at 11:37, and he testified under oath on cross-examination, yeah, it was 12:09 a.m. when we got the call.
You don't think a half an hour is reasonable?
I absolutely not. I don't believe so. My client has been pulled over and blocked in, is not free to leave, by a Merrimack police officer in Amesbury and detained for 30 to 35 minutes is not reasonable. The cases that I read typically dealt with, I think it was the Sterling police, 45 seconds, 1 minute.
Well, I thought there was testimony that there was a clock differential here. I mean, nobody testified that your client was held there for 35 minutes before the police arrived. Who testified to that?
The Amesbury police officer testified to that.
That your client was held there
Well,
for
he didn't say that
35
he was-
minutes.
No, you're right.
No, he didn't say that.
No, he didn't say that.
And the officer who stopped him, but didn't arrest him, stopped him,
Right.
And then contacted the Amesbury police?
Amesbury police.
And they came and actually, what, did they do a field test right there?
They came and did a field test.
The whole 9 yards.
And did the observations, bloodshot, glassy eyes, made the arrest. Amesbury police took him away.
Right. So the officer testified that the response was quite immediate.
Well, I mean, it's certainly circumstantial but reasonable to believe that my client was detained. I mean, he wasn't allowed to leave. Merrimack police pulls him over at 11:37. There's testimony under oath, and I can point to the actual pages of the transcript, Judge, that he's there. The call comes in at 12:09. That's 35 minutes. That's 35 minutes that my client is detained.
And there was no explanation as to why those times might have been incorrect?
The officer from Merrimack said maybe there was some discrepancy in the
And that
clocks
they've
in
had
the
that
police
experience
cars.
before.
I don't know that there was testimony as to that, but I think that is unreasonable.
What did the judge find?
The judge, as far as the clocks,
Well, as far as the notification.
the judge credited the Merrimack police officer's testimony that he called Amesbury within 1 minute. And I believe that that was clear error by Judge Welch to make that finding in light of the testimony by the Amesbury police officer, who would know better than the Merrimack police officer because he had a police report that he said, yeah, I wrote 12:09, and oh, by the way, I agree it was 12:09. And I think those 35 minutes are important in dealing with the issue of the mutual aid agreement. If he hasn't made prompt notification, certainly he could have called the police while he was behind the car. Certainly he could have called the police when he blocked the car in. Okay? But if you believe the Amesbury officer, who's got nothing to lose in this case, I mean, he's testifying, yeah, we got the call at 12:09.
So what happened in that 35 minutes?
No one knows. I mean,
Well,
we
there
can
was no,
certainly speculate.
I tell you, the officer who made the stop didn't say it was 35 minutes.
No,
he
he
said he
didn't.
called immediately.
Right, he
and
says
the
he
judge
did.
credited his testimony.
That's correct. And my
Has your client
argument-
shown any harm? Even if he were stopped for 35 minutes, where's the harm?
The harm is that it would be in contradiction to the mutual aid agreement, which requires prompt notification. It's my argument that having my client at midnight in Amesbury, in a parking lot, in his car, detained by a Merrimack police officer for 35 minutes is unreasonable and is not prompt notification, Your Honor. It's not. And under those circumstances, I would say that the mutual aid agreement doesn't fly in this case.
What about the other statute?
Right. That was the other argument that was made in this particular case, Chapter 37, Section 13, which deals with, just get my notes here, which deals with preservation of the peace. And this is the case where Judge Welch, he basically said that I don't really need to reach the mutual aid agreement because 3713, I believe, in this particular case, the officer from Merrimack was making the stop in preservation of the peace. And he analogized the case to Twombly. And my argument is that the cases such as Twombly, Leahy, I believe Morrissey, and Harris, these are cases that go far beyond the actions that were observed by my client in operating his motor vehicle. In Twombly, we had, I believe he was coming off of 495, speeding, illegally passing cars, driving at a high rate of speed, certainly much more of a danger, and certainly could have been charged with driving to endanger, much more egregious than my client's 20-second time period of when he crosses marked lanes.
I had thought that your argument was that there has to be a request by the host police department for this to be triggered.
Well, that's part of it. I mean, it's a two-part argument, Judge. What I'm saying is that if in these cases, I think that if we allow...
So let me ask you this. I mean, if this particular officer had said, I see a guy who I think is driving under the influence, calls up Amesbury and says, I see this, and the Amesbury police officer says, you're right there, why don't you stop him, would that not fall within Section 13?
Well, I think if he had done that, that argument could be made, but he didn't. So I think that's a
I
good
know,
point.
but I mean, the question is what Section 13 means. Are you saying that person driving drunk is not, that stopping a person who is driving under the influence is not in the preservation of the peace?
That's not what I'm saying. What I'm saying is
And I'm
that...
not sure what you're saying then.
Okay, well, I'll try again. Fact specific to this case, okay? The officer is in a different jurisdiction. He sees my client cross marked lanes. He does not make a phone call and get the transfer of authority that occurs in other cases. He doesn't do that. So I misspoke earlier when you asked me that question, Your Honor. I apologize. He didn't do that. But what I'm saying is that Judge Welch said this case is analogous to Twombly. And what I'm saying is it's not. Because if we allow police officers in any jurisdiction to stop other cars because someone crosses marked lanes, then liability reasons, cost reasons, it would be a mess. That's what we have state police for.
That's exactly what didn't happen here. Assuming that would be accurate assessment of what the responsibility would be, he actually did follow. He sees somebody cross a marked lane. You said once, but the finding was that he then follows him for, I guess, about half a mile, and he sees him cross he first sees one thing, crosses over a yellow line, comes back. Then he continues to cross the double yellow line 4 times and the fog line 3 times. That was after the first observation. He was making sure it wasn't just, bad driving. And every violation was a substantial amount, more than just bumping the line. It was at this point that he abruptly stops in the middle of the road, the car he's been following, to see, is it just bad driving or is it more than that? Turns into the restaurant where he doesn't park in a parking spot, right in the middle of the entrance, but just right in the middle of, in the road, the driveway. And that's when he not only stops, looks to see, is there something indicating that this is more than bad driving? And he sees the, the indicators of, bloodshot eyes, and then he makes the call. Wasn't that appropriate conduct, just of the kind that you're saying should occur, rather than, oh, he's crossed the red line, let me call the police and get them over here to arrest this guy?
What I'm saying, Your Honor, is that I think it's opening a can of worms to allow a police officer to make an extraterritorial stop with no fresh pursuit, having not witnessed any arrestable offense in his own jurisdiction anywhere in Massachusetts for a civil infraction of crossing marked lanes. everybody is jumping to the conclusion that the officer was pulling over a drunk driver. He was pulling over somebody that he suspected may have been intoxicated. I grant you that. But he didn't have any information beyond someone crossing marked lanes. And if we allow police officers in Massachusetts carte blanche to pull over any car in any jurisdiction for a marked lanes violation, I think it's going to cause...
But that's typically what initiates somebody being pulled over, and it's later learned that they're operating under the influence.
And that's true. And if that's in your own jurisdiction and the stop is good, then I wouldn't have a problem with that.
Would you have a problem, same facts, but he had called before he actually stopped in front of your client's car?
I think I would be remiss if I didn't say that would make a big difference.
So that you think might trigger the Section 13?
I think that's how it's written. I think that was the legislative intent. I don't think it was for the officer to do what he did in this case.
All right,
very
thank
much.
you very much.
Good morning, and may it please the Court. Paul Wagoner for the Commonwealth. I just want to clear up a couple of fact issues that may have arisen from the defendant's arguments. As Justice Duffley noted, there were 7 substantial marked lane violations, 4 on the left, 3 on the right. We also know from the trial evidence that the business was closed at the time.
The Chinese restaurant, you mean?
The Chinese restaurant, exactly. There was another car in the parking lot. That's in the suppression hearing transcript. It's not clear. It's pretty clear at the trial that the only other car was his passenger, who we know from the trial evidence was also drunk. And so the marked lane violations, though, are on page 8 of the suppression hearing transcript. Additionally, the last fact issue I want to clear up is that the judge did credit the testimony that these clock synchronization issues have arisen over the years between the 2 police departments. They have interoperable radios, and there's the computer networks. There's a ton of testimony about sort of why this comes up, why it might come up. I suspect, although this isn't necessarily apparent from the record, that the Amesbury officer's junior partner may have written or drafted his senior partner's report, remembered it being around 12:09, whereas the Merrimack officer remembered it being around 11:37. The Amesbury officer who testified remembered it being at 11:45, sort of agreed with the prosecutor, and then when on cross-examination he was presented with his report and that of his junior partner, he said, well, you know, if it's written there, it's 12:09, it's 12:09. There isn't a real clear indication as to when this conduct really occurred and how long it was there, except that everybody seems to agree that the Amesbury officers, who obviously had jurisdiction, were there within a minute. Officer Skasha testified that within 45 seconds, the Amesbury officer, Kevin Mulgrennan, said within a minute, and the judge credited that testimony.
And
It's supported by the evidence.
And maybe this has the same synchronization issue, but did they then call to dispatch and say, I'm there, and does that time get reflected, or is that part of the same thing?
They being the Amesbury officers? I don't know. I'm not sure why they would necessarily. Oh, I see what you mean. Because it might provide a little more evidence one way or the other. There's just nothing in the record about it.
Now, there's nothing to indicate that the Amesbury police requested help at any point.
Well, Officer Skasha, the Merrimack police officer, there's a finding by the judge that he made, he let them know what was going on as soon as practically possible.
But it was after he had, but basically it was, they never requested his aid until after he had already blocked the defendant's car.
That's right. That also doesn't seem to be a requirement under HE, which is a very broadly written statute authorizing mutual aid
but that's not what the
agreements.
cases construing it have indicated. In fact,
AG or 13?
3713 or HG?
I'm sorry, I'm not looking at the, I'm looking at the 37.
3713?
Yeah.
That's correct, Your Honor. And in many of these cases, Twombly, Morrissey, Leahy, there does seem to be some prior approval. The cases aren't necessarily conditioned on that fact.
Well, but
although
the
I
statute
agree it's
itself
present.
authorizes officers acting within their own proper jurisdiction to require the aid of third parties, including other police officers. So it's, you know, it seems to me that there is nothing in the statute which appears to authorize extraterritorial officers' actions on their own initiative. And I think that's what the cases may be reflecting.
No, I agree that there is some dicta and limoni that seems to...
And we don't have anything like that here.
Except a finding by the judge that said it was as soon as practically possible. He
I
let him
understand
know.
that, but it was after the fact.
The call.
It was at the time of the stop. The call was at the time of the stop.
Makes the stop and he's calling.
He actually didn't make the stop. The defendant stopped his own car of his own volition.
Well,
He
but didn't the
simply
judge
blocks
make
it
a
in.
finding that it was a legal stop? That, after he pulled up in front of him, pointed his
Wasn't
lights
free
at
to
him and blocked his car, that was a legal stop? That's what I'm referring to by the stop.
Absolutely, yeah.
And that was at that point that, up until that point, he had not gotten a request from anybody that he do that.
Right, but I think we're sort of splitting hairs here. It was a
Are we?
20-second observation, a half mile. There's 7 marked lane violations. He testifies that the defendant stops at the first entrance abruptly. He goes to the second and says, gosh, I just can't drive by, and goes right in. Certainly the officer in Leahy maybe is able to divide his attention and call as he sees the defendant swerving into the other lane of traffic, but it's not clear that that should be a requirement.
Well, that happens in Twombly, and it happens in other cases as well under 3713, that the officer is getting told, please do this for us.
That's correct. There's only one case I found where an officer, at no time prior to the stop, was there any communication between the officer and the local authorities. It's Commonwealth versus Payette. It's a 128 decision from the appeals court justifying the stop under Twombly. I do think that the statute is a little bit convoluted. As you noted in the appeals court decision in Twombly, it says requisition of aid. I'm not sure that that should be a strict requirement, especially in preservation of the peace cases. As I mentioned, his attention was focused on this officer's, the officer's attention was focused on the defendant's conduct, whether it required an immediate response, and whether it could cause harm, injury, or destruction, not on whether at that exact time he should be asking for
Let me ask you a question.
explicit authority in advance.
Under the agreement, it requires an immediate, it permits extraterritorial action when there's an immediate response or action necessary for the good of public safety. Is that roughly the equivalent of the preservation of the peace in Chapter 37, Section 13?
I think so. This agreement is actually, as I'm looking at the agreements across the Commonwealth, pretty narrow and circumscribed. And I think in the agreement itself, it says, we're hemmed in by the case law and the statutes. We can't, extraterritorial officer can't act beyond that. It also says that the requisition of aid may be similar to 41 Section 99 powers, which is the clear preference of this court in this situation. And certainly the judge seemed to think that if it satisfied one in terms of the emergency or the public safety issue, it satisfies the other. I just want to talk about the defendant's conduct here. It's not a simple marked lane violation, and that wasn't the case in Twombly. Twombly involved speeding and improper passing. These were civil infractions characterized as erratic, as in this case, that could cause harm, injury, or destruction, and they required an immediate response. And I think that's a clear standard for an officer out going and getting a coffee in another town. If he sees this going on, he says, this isn't just a civil infraction. This is a civil infraction that's characterized as erratic. It could cause harm, injury, destruction, and it requires an immediate response.
If the defendant was still driving, there'd be no. It seems to me to be a lot easier to say that was stopping him was warranted for the crossing overs, the four and then the 3 that he saw. But here the defendant stops in a parking lot. Wasn't there an alternative for the Merrimack police officer to park in the same lot with him, keep an eye on him, and in the meanwhile just let the Amesbury police come and take care of it without actually having to go any further?
Sure. Absolutely. He could have done less. I think Oren versus
And
Ware
still serve the public safety.
No, but he could have just driven away.
I'm sorry?
I mean, couldn't he have just driven away?
He could have just driven away, absolutely.
I don't, the he in that sentence was the defendant, not the officer.
Then you'd be in a chase situation.
Yes. No, but I really do think the lens through which to view the officer's conduct, though, was Lamoni. He was simply freezing the status quo here. Is a reasonable investigatory stop by a citizen? He could have done this if he was a citizen. He could have called the police and just simply prolonged, kept the defendant there until the local officers arrived. He doesn't, when he walks up to the defendant's car, do anything that we think of officers doing. He didn't try to develop probable cause. He said, "Can I see your license and registration? The local officers are on their way." But he doesn't ask him any questions about how much he had to drink tonight. He doesn't put him in the back of the car like the officer in Lamoni, the extraterritorial officer in Lamoni does. But that might be appropriate because the conduct of the defendant was less. There wasn't an accident. There wasn't something that might be seen as a breach of the peace, although the conduct here is very similar to Morrissey, where a breach of the peace was found, narrowly missing a pole, going through a stop sign, and Leahy also involves similar conduct, although the motion judge sort of hemmed the appeals court in to the inevitable discovery doctrine rather than 3713's breach of the peace provision.
In Lamoni, did the pursuit start in the officer's jurisdiction?
In Lamoni, the officer was rear-ended. The officer was also off duty.
Oh, that's right, he was off duty. Okay.
Yeah, and so I think this officer, realizing that he was sort of out of bounds here, took proportionally more circumscribed conduct.
So you're saying, okay, so you say this is like that, and we don't even have to worry about mutual aid or anything. It's a valid citizen's action in the face of evidence of drunk driving. Is that what you're saying?
That would be a fantastic ruling from this court for the
No,
Commonwealth.
I'm just trying to figure out what you're saying. I'm not saying. Is that what you're arguing?
Absolutely. I think it's a good way to look at the officer's conduct. I do think that the clear preference for this court for the specific officers to be sworn in under Chapter 41, Section 99, perhaps should be explored here. It doesn't seem to be workable, and the amicus seems to make this argument maybe more artfully than my brief does, that this is workable in a situation where we have 5 towns, a rural community. The amicus talks about the Cape, where the population doubles in a given season, and the 5 towns on Martha's Vineyard, or I'm not exactly sure where it was, they operate as one police force, and officers come and go. It doesn't make a whole lot of sense to me, especially without an explanation from this court and the appeals court about why that preference is there. It's very clear that the preference is there. But frankly, both of these procedures are ministerial actions with continuing validity, and there's no extra training that goes with a 41 Section 99A officer who's specially sworn. It's a sort of clumsy approach to limiting extraterritorial officers without some guidance about the provision of personnel services in mutual aid agreements and what this court expects, because we don't want to be here. We want to do the right thing.
I'm not sure I get what you were just saying. Are you saying that what you're advocating for is that we find that the stop is simply authorized by the mutual aid agreement, as opposed to requiring or preferring that officers be sworn in as each other's special police officers under 4199?
That's correct. The court has a clear preference in LeBlanc and Grise, and I think some of the single justice matters before this court, that if an extraterritorial officer acts, he or she be a 41 Section 99A specially sworn officer. Here, however, the officer wasn't, and this mutual aid agreement and the officer's conduct provide a vehicle for this court to demonstrate its expectations when personnel services are provided across territorial lines when there's only a mutual aid agreement justifying the officer's extraterritorial conduct. Is that clear? And so I'm happy to talk about how this mutual aid agreement in particular complies with Section 8G.
If we can go back to Section 13, I'm a little bit, is it your view that a request for aid is not required under Section 13?
It is my view that that has never been an explicit ruling by this court, although it is present.
Okay, but try my question. Is it your view that the statute does not require there to be a request for aid?
That's our view, Your Honor, yes.
But if that's the case, though, I mean, statute says police officers may require suitable aid in the preservation of the peace. I mean, doesn't this raise the issue of there being a demonstration in Boston and Cambridge sending 20 officers and Boston saying, we actually want you here. We're handling it adequately. Why should a police force be able to interfere with the ability of a police chief to decide how they want to handle an issue with regard to the preservation of the peace?
Well, that's not this case.
Well, I know, but if that's your interpretation of the statute, then in my example, Cambridge can send 20 police officers to handle a demonstration, which Boston says we're handling just fine.
I think that's unlikely. It seems I don't have a good answer for you, Your Honor, and I do see my time is up.
All right, counsel. Thank you.
Stay by the clock.